The Federal High Court sitting in Umuahia, Abia State, has ordered the Attorney General of the Federation to immediately delete Section 84, Section 12 of the Amendment New Electoral Act. The court, in a judgment delivered by Justice Evelyn Anyadike, held that the section was unconstitutional and invalid. Justice Anyadike further stated that the section ought to be struck down as it cannot stand when it is in violation of the clear provisions of the Constitution. While signing the electoral bill into law last month, President Buhari had asked the National Assembly to delete Section 84, subsection 12, which restricts sitting cabinet members from contesting for elective offices without resigning. However, the Senate refused to consider the president's request, with lawmakers stressing that an amendment would be going against the civil service norms and would be injurious to the well-being of the society. Well, to discuss this further, Adewale Ajadi, legal expert, joins me now. The Attorney General of the Federation had earlier slated that the federal government would pursue the issue further in court. But where do you expect, what do you expect the outcome to be, really?
Good evening. I mean, it makes absolute sense. I mean, the constitutional provisions are very clear. So, for example, Section 66(1)(f) clearly provides for the duration of time being 30 days for resignation. You cannot limit people's constitutional rights by act of parliament, and you have not amended the Constitution. So basically, it's no surprise at all. And if we look at it in retrospect, it means the president was right in his opinion that the section of the amendment should have been removed. And he's absolutely right, because the constitutional provisions are extremely clear. And anybody who bothers to read the Constitution will see that they're extremely clear.
Now, what do you think the next line of action would be from the lawmakers? Are you expecting them to back down, or do you think they will appeal this order?
It's not a back down issue. It's a matter of amending the Constitution. They have the right, if they have the numbers, to amend the Constitution. You see, part of the problem is that we reduce this thing to issue of personalities. It's not an issue of personality. There's an existing provision. If there's no existing provision, then it's an issue of personality. But it's extremely clear what the Constitution states across many sections, not just Section 66(1)(f), but I think Section 104, 1F. I'm not exactly sure. And I think 182, 1F2. These are all provisions that gives rights to existing members of not just the executive, but also the legislature, and certainly makes it clear that they have 30 days to resign before an election. So anything else that takes away the rights of Nigerians, we should be really concerned about. Except we change the Constitution, then it stands as the judge has ruled, in my opinion.
But in terms of the argument for against this part of the Electoral Act, now, do you think the 30 days notice towards election is too short for this public office holders?
I don't. You see, it's not a matter of an opinion when the Constitution states something. The Constitution is the supreme law of the country. It states very clearly that this is their right. You know, whether we think it has merit or not, that's what's in the Constitution. I certainly think that actually all of these issues are actually trying to fetter certain individuals from having the rights to contest for an election. And anything that limits representative capacity itself, in my opinion, is actually unjust and unacceptable. Anything that limits anybody's constitutional right to act, to represent their people, to compete for an election, should not be accepted on principle. It's just unnecessary politics.
Well, indeed, Adewale Ajadi, legal expert, thank you so much for your contribution.